Hello, everyone, and welcome. My name is Trey Harding at Gutmann and Bogart Insurance Brokers. We're going to get started here. I'm going to go through a few items with you before I introduce you to our guest speakers today. Returning to work from COVID-19, navigating through employer concerns. We are the hosts, Gutmann and Bogart, and our featured speakers today are Chris Harmon and Jill Grathwohl of Lewis Brisbois. As the economy gradually reopens, we know you do have challenges. Our first guest speaker today is Chris Harmon. Chris is a partner in the Orange County office of Lewis Brisbois, and he's a member of the labor and employment practice. Chris prides himself in helping guide clients on best practices to prevent lawsuits, as well as defending employers of all sizes in the event of an employment-related lawsuit. Jill Grathwohl, she will follow the second portion of the webinar today, and Tammy Daniels of Bogart, she's our Director of Workers' Compensation Claims, will be involved as well. Jill is a partner at Lewis Brisbois in the San Diego office. She is also the vice chair of the Workers' Compensation practice. She specializes in workers' comp defense and will be sharing the current status of COVID-19, the presumption of workers' comp claim. As you all may be aware by now, Governor Newsom came out with a big update for California as of yesterday. And a couple of housekeeping items before I read our disclaimer. Please feel free to ask any questions in the chat box. Due to time constraints, we'll follow up on all these questions individually. If you have specific employment law or workers' comp law questions, please do not hesitate to reach out to our featured speakers today, Chris Harmon and Jill Grathwohl, or your employment counsel of choice. One other item, in your dashboard, you'll notice that there's a title called Handout in the section of the webinar dashboard. Feel free to download this presentation. We also will be recording this presentation, and it will be available on the Gutmann and Bogart website. Finally, as always, do not hesitate to reach out to your Gutmann and Bogart broker for guidance and direction to refer you to the right person if you have any questions. And as far as our disclaimer goes, any information provided by the speakers and/or Lewis Brisbois in or from this presentation is for informational purposes and shall not be considered as legal advice from Lewis Brisbois or as creating a professional client relationship between the person and Lewis Brisbois or any of its attorneys or staff. This presentation contains general information and may not reflect current law or legal developments. Any person viewing or receiving information from this presentation should not act or refrain from acting on the basis of such information, but instead should seek appropriate legal advice from a qualified professional. Lewis Brisbois expressly disclaims any intent to provide legal advice to or from client relationship with any qualified professional. Furthermore, Lewis Brisbois disclaims any liability whatsoever with respect to any actions taken or not taken by any person based on the content of this presentation or any information contained herein. Gutmann and Bogart's disclaimer is this communication is not intended to provide any legal advice or opinion on any individual situation and should not be relied on to determine insurance coverage or lack thereof as it relates to the coronavirus. Insurance forms and endorsements vary based on insurance companies. Changes in addition dates, regulations, court decisions, and state jurisdiction. The information is based on review of insurance coverages, sources we deem to be reliable, and communications we have received from insurance companies and other resources. We make no representation or warranty as to the accuracy of information as applied to individual cases. Without further ado, I'd like to introduce you to Chris Harmon.
Thank you, Trey. And I think you actually had the hardest job here because reading those legal disclaimers might be the toughest part of the job today. I'd also like to thank everyone for joining us today and taking time out of their day to just listen to the latest and greatest on reopening businesses and dealing with the current guidelines that are in place. I'd also like to thank my wife for my quarantine haircut, because but for her ability to use some thinning shears, my hair would look like the Planet of the Apes. So thank you to my wife, and welcome to my room slash office. During these times, things have changed, but we're all trying to navigate through what we can, at any given moment. What I'd first like to do is kind of tell you who I am. I'm an employment partner with Lewis Brisbois. And not only do I represent employers through in litigation, I also provide counsel and advice in real time to try to avoid litigation or any pre-litigation claims. So that's really what the coronavirus sort of preparation is. It's a lot of preparation before you reopen the doors, and that's really what we try to do here at Lewis Brisbois on the employment side is provide you with the information that you need to consider and the policies that you need to have in place once you reopen those doors. First, it's pretty important to go back and look at this title, navigating through employer concerns. And I think the key is in uncertain times. To me, that's a very powerful message. And the reason is that, we're all trying to basically find the approach that works for us, whether it's being more lax or, playing it safe or even extra safe. But even when you play it extra safe, that also comes with risk. And that's something that we'll talk about today as far as how you can try to avoid some of those risks and navigate through those risks in these uncertain times. A couple, practice points and thoughts that I've seen with my clients who were essential businesses, because today's focus is on businesses that weren't currently already opening, but it also applies to businesses that were already open because they were essential businesses. An issue or some points would be, first piece of advice is foster connection with your employees, okay? These might go without saying, but they're very important points to key on when you first start thinking about reopening your doors. You as the employer or the HR staff or the management, you need to be the role model. You need to reassure employees that you're doing everything possible to make sure that things can be as close to normal as they can be. You need to also act inclusively. Make sure that everyone's involved. No one's left behind, no one's left out as far as your communications. And risk, over communication. You want to make sure that you're transparent about what's going on, what guidelines you're being provided with, and things are going to change, but your employees are going to appreciate being a part of the ride and understanding that knowledge is power, especially in uncertain times. The last point or tip is practice agility, because things are going to change. Literally last night, things changed on the workers' comp side. I guarantee during this webinar, there's a chance that a new executive order comes out, and the advice might change for tomorrow. And if you're keeping it simple, Trey brought up a good point before we got online, but think like a Navy SEAL. The way they go about their problems is adapt, improve or improvise, and overcome. And that's really what your job as an employer is going to be. So let's get to some basics. When can businesses go back to work? That's an important question. And according to Governor Gavin Newsom, we believe we are weeks away, not months away from starting to make meaningful modifications in the current restrictions. That's saying a lot without saying a lot is what I'd say, is kind of giving you a guideline that, we're getting close, but even though we're getting close, we're not going to completely reopen. And that's the good news. The uncertain news is that while current public health indicators such as hospitalizations and testing capacity look promising, additional progress is going to be needed to be, go towards reopening all different types of businesses. The state issued 6 indicators that it's going to look to guide the modify the stay-at-home orders. First is increased testing and contact tracing. Try to figure it all out. Systems for protecting the most vulnerable positions, such as seniors. And really, when they say seniors, I prefer calling them mature adults. That's probably the best way to say it. Ensuring hospitals are equipped with the equipment they need to handle a patient surge when we reopen. Engaging research partners to develop therapeutics. Issue new social distancing guidelines for businesses, schools, and childcare facilities. And the last is developing the capacity to reinstate new orders when necessary. And this goes to my point of being, agile and the ability to adapt new policies. And that goes with, hand in hand with communication with your employees. Next, in anticipation of the modifications, Governor Gavin Newsom announced a 4-phase plan. And when we first started drafting these slides, we were still, currently in stage 1 and did not know when we were going to be in stage 2. But now, as of tomorrow, we're going to start diving into stage 2, and it's really baby steps. People are still going to be staying at home except for essential workers in certain industries. In stage 2, schools, summer programs, childcare facilities, and really low-risk businesses, stores, which include some retails with curbside pickup, some non-essential manufacturing companies, will basically allow the modifications to allow them to reopen. Well, what does that mean, reopen? It means that you're going to have to prepare, institute social distancing policies. It's not business as usual, and there's a lot of considerations that we'll go through that you need to look into before you even reopen your businesses starting tomorrow. And tomorrow doesn't mean that you open the doors tomorrow. It means that you start now, and hopefully you started before today, starting to think about some of the ideas and policies you need to put into place. Stage 3 would be the high-risk workplaces that will start to reopen. We're not there yet. I don't even think we're close to there yet, but that includes personal care, entertainment venues, and in-person religious services. Stage 4, this would be the end of the stay-at-home order, and it would be reopening the highest risk part of the risk parts of the economy, concerts, convention centers, etc. Do the rules and best practices differ? And this is a good question. Do they differ between Fortune 100 companies and small businesses, or between essential and non-essential businesses? Short answer is no. Everyone's in the same position, trying to navigate with the same written guidance and executive orders being provided by the state at the federal level and also the local level as well. But just keep in mind, even once the stay-at-home order is lifted, Newsom mentioned that society won't snap back to normal. Things are going to be different for a while, and it's going to be our new normal until it's not. But there's no timeline as to when it's going to end. There's no light switch here. It's more like a dimmer, and that's a good point. And that's just a mindset that I think employers need to have, let alone just the general public. Normal, what is normal? It will not be until we have herd immunity and or a vaccine. And really, again, getting used to, before you go to dinner, either your waiter wearing gloves, maybe a face mask, maybe they checked your temperature before you walked in. We don't know exactly what it's going to look like. But when we do return to work, what laws, rules, and protocols do we follow? This is my son's favorite slide, and he keeps asking about the dog and whether or not we can get a dog now that we're at home. So I really like this photo. Types of rules and regulations. It's important to understand, as employers and HR staff, there are 3 types of orders and laws. There are federal laws, such as the Family First Coronavirus Response Act. There are state executive orders and protocols, which is currently in place is the California Executive Order N3320. And then there's local county executive orders and protocols, which I'm in Orange County. I have clients in San Diego, Orange County, LA, San Francisco, and things depend upon where you locally are situated. I'm going to use Orange County today. It's a little easier to go through some of their examples, but an example of a local executive order is Orange County's public health order, which was issued on March 17th and was quickly amended because of some confusion that it started the next day. So that's how quick things can change. And how do these laws work with with each other. And, this is a constitutional issue that they teach back in law school. And, who has the power to do what? The federal government, by way of the Constitution, can print money, declare war, and regulate commerce, interstate commerce, that is. So, and we can dive into the case authority that allows states to really reserve the power to regulate a situation like this, which we're currently seeing, which is a pandemic. States have the power to guard and protect. And this is not necessarily something that's a federal issue. They do provide guidance and support, but as far as the decision to reopen, that's going to be left with the states. Partially, the CDC also has limited authority to quarantine individuals, and that's really on a case-by-case basis, but that's really only to prevent the spread of the disease. Where can businesses look to find these guidelines, whether state, federal, or local, and the protocols to put in place? While there's no bright line rules, there are numerous written guidelines to follow from the following state and federal administrative agencies: EEOC, the CDC, the FDA, OSHA, whether it's OSHA or Cal OSHA, the DOL, DLSE. It seems like I'm making these up and I'm just picking, letters out of the alphabet, but these are all organizations that you should check. I mean, before I got on today, I have on another screen, I have the EEOC open, I have Cal OSHA open, I have the CDC, because it's just good informative reading. And a lot of the topics and things we're going to talk about today came directly from the EEOC and or the CDC or Cal OSHA, and it's just good to go to the source, and they do a good job of making it easy to understand, and they're pretty prompt about giving new guidelines on a weekly, if not daily basis. Orange County, let's take an example of local ordinances which will provide best practices for businesses. In advance of even getting into the second phase, they released their best practices on April 28th. First issue that they talked about would be, once you reopen, physical distancing in the workplace. I know it's going to differ from employer to employer, but physical distancing at a minimum of 6 feet should be maintained, especially between customer-facing employees and the general public. You have a consideration of keeping your employees safe, but also your customers safe, and to the extent practical, between the employees at their workstations. So this is going to be a very, very idiosyncratic analysis that you do. How do we figure this out with the space that we have? But it's something that's going to be dynamic and changing. The second issue that they have is hand washing, personal protective equipment, also known as PPE, and also testing. Employers in Orange County should require, is what they're telling all businesses, all customer-facing employees every 30 minutes to wash their hands. Use hand sanitizer, wear disposable gloves. Face covering should be provided to all employees. We'll talk about whether or not that's mandatory or optional in your local, based upon your local ordinance, and who has to provide that sort of equipment. Businesses should make every effort to limit touch points, and before starting a shift, the employees should have their temperatures taken and not permitted to work if they have a reading that's above 100.4. We'll talk about that later on today. Also increase the frequency of sanitizing workstations and the equipment that come into contact with the general public. It's just the new normal. This is a job duty that someone's going to need to be tasked with once you reopen. Face coverings and gloves should be worn by all customer-facing employees. Visitors to businesses, establishments should also wear appropriate face coverings. So hopefully our customers are following these rules, but Orange County wants to make sure that not only the employer, the employees, but also the visitors are being knowledgeable as to what they should be utilizing during this pandemic. Vendor compliance, businesses should talk to their vendors. If you have people coming in making deliveries, you should prepare guidelines and expectations for those vendors. It's just something else to think about. But another great resource, the EEOC has recommendations for employers for dealing with all of these situations. So Go to their website, and they'll provide you with the guidance on, they even have a return to work sort of guidance section that is pretty straightforward. Next topic, what can an employer do to prepare when businesses return to keep their employees safe at the workplace? This slide, preparation is key, is really the way I live my life. And the other picture on this slide is a target. It's kind of like throwing darts. You're aiming to hit the middle, but it's just an aim point, and it's a target that you're trying to hit. And it's something that you may not hit the first time, but you're going to work each day, each incident, each situation that comes up to find a target that is in conformance with the guidelines that you're provided. Here's the checklist of items to discuss before reopening. First, determine which employees should return first. This is just, when the doors open, that does not mean that you need to necessarily bring everyone back to work, because the customers may not return at the same rapid pace that you believe they will be. First, identify essential business functions and who the essential employees are. Second, prepare a communication to the employees, providing them with the guidelines that they should follow at work. And actually, I'm going to touch on a few points on the first issue, which is determining who should return to work first. Create job description sheets. This is a good time. We have a lot of downtime now, but make sure you have written job identification, job duty sheets, because they'll come in handy when you're dealing with accommodations. And they also come in handy when you're trying to determine who's essential. They're going to look at the nature and the function of the job, the ability, whether or not this employee can return to work safely, if that's a possibility. You're going to look at employee performance. That's going to be an issue. Who are the people that are more efficient in what they do and maybe can handle more than one job? And really any other non-discriminatory sort of criteria is what you should use to determine who should return to work first. On my second point that I just addressed, communication, it's something that you're going to rely upon your employees to do. Personal judgment calls, self-reporting guidelines and expectations for them to inform you of kind of what was going on before you returned to work and even during the time they returned to work. Third, develop a written protocol for all confirmed or suspected COVID cases. This dives into the EEOC and Cal-OSHA guidelines and whether or not you have these reporting requirements to document the confirmed and suspected cases. 4, anticipate employee anxiety, rumors, misinformation, and plan accordingly. This is the transparency that's required, and this is going to happen, and you just have to take steps, which dives into the next one, take steps to make sure that the workplace is more safe, and that's through your managers, that's through your executives, that's through your supervisors, and really informing the employees as a whole. 6, to the extent possible, implement social distancing requirements such as staggered breaks, staggered shifts, spacing between desks and community areas. And this is something you can be doing now before you open. There's also a point that you should limit in-person meetings in favor of virtual meetings wherever possible. You should minimize as well physical contact, handshakes, cough etiquette, which is again something I taught my 4-year-old, but it's something that equally applies to everyone in the workplace today. Elevators, it's a situation where it's a personal judgment choice and you're really empowering your employees to make the right sorts of decisions. If the elevator's too packed, wait for the next elevator, but you're trying to minimize that contact. 9, limit or close off gatherings in common areas. 10, educate employees regarding best hygiene practices and intensify your sanitation mechanisms in place. 11, promptly respond to any safety-related concerns. This is an issue. Everyone is going to be concerned when they return to work, but you just want to make sure that you're addressing those concerns in real time, not a couple of days later, but just in real time. Consider temperature checks and COVID testing for your employees and your visitors. And there's different rules for both, and we'll talk about those. 13, Consider whether face masks, gloves, or other PPE equipment is mandatory or optional. If mandatory, the company must provide or reimburse employees for masks, gloves, or other PPE equipment. If optional, determine whether or not the employer will place any limitations on employee-created PPE, masks, gloves, etc., because not all PPE gear is created equal. And there's certain requirements that are out there as far as what's allowed, and the CDC goes into what is the proper PPE gear to be using, and also the proper use. Don't take that for granted. How you take off your mask and where you place it, you just don't want to recontaminate anything that you believe is sanitized. What type of PPE gear is required? The answer is check the CDC's website. But what I can tell you is that both of these pictures here are not proper PPE gear to be using. And I even tried creating one of these orange slides at my house. And while it does smell better than the masks that we're probably using on a day-to-day basis, it's not an effective device, which is sanctioned by the CDC. And on the other end of the spectrum, depending upon your business, you also don't want to be on that end of the spectrum, in which Dwight is utilizing at the workplace. Are there best practices that employers should consider when conducting body temperature testing? I love this picture as well, because we all know that babies learn one way to take their temperature. What should I be concerned about? There's legal and practical concerns when you implement an employee body temperature test. And the whole goal is reducing transmission and the risk of the COVID-19 virus. There are privacy and employment law considerations. What do you do with the information that you're provided, and how are you keeping that information private and confidential? And these are things you're going to need to contemplate, and new processes that you'll need to put into place. Also, employers should also consult with qualified medical professionals to make sure that the medical information and the equipment that you're utilizing is effective, because that will also lead to another possible concern, which could be possible false positives or false negatives. And utilizing and going to, even the FDA, the CDC, Cal OSHA, the EEOC, they know that these false positives, false negatives will occur. So just make sure you're using the right equipment and you have these policies in place. Application to third parties. The rules for testing body temperatures for anyone that is not your employee, such as customers, contractors, suppliers, patrons, have different considerations, different laws that may apply. So it's something you're going to want to get ahead of. Here's the legal standard for why we're able to body temperature test today, which is different from before because it's something you necessarily would not qualify to do, with your company. The ADA requires that mandatory medical tests of employees be job-related and consistent with business necessity. These are fancy words that actually really mean things in the environment we work today. In applying the standard to the current environment, employers may take steps to determine if employees entering the workplace have the virus, because such an individual will pose a direct threat to the health of others. And that's why they allow us to test in the workplace. Whether or not an employee poses a direct threat to him or herself or to others is determined on the best available objective medical evidence. There's guidance from the CDC and the public health authorities, which allow you to identify certain symptoms and certain regulations and definitions as to determining whether or not someone is a direct threat. Possible questions for managers. What type of temperature readings are we looking for? The CDC considers a person to have a fever when he or she has a measured temperature of at least 100.4. What symptoms should we be looking for? The CDC has identified the following as symptoms associated with COVID-19, and this has evolved: fever, a cough, shortness of breath, difficulty breathing, chills, repeated shakes, muscle pain, headache, sore throat, and a new one is a new loss of taste or smell. Best practices: establish a clear policy for for this testing. Notify your employees about the testing program. Make sure it's compliant with the CCPA, and there's a notice that should go out to your employees. Use touchless thermometers. Ensure that it's being applied equally to all employees, not just some employees. Make sure that you're providing the PPE gear for the people taking the temperatures. That's something to consider. This is all general guidance. Again, I'm going to go a little faster only because we have additional slides to go through, but check with your employment counsel. How should employers handle disability accommodation requests during the pandemic? First is to keep calm and always remember the interactive process. It's the standard interactive process that you'd be required to engage in on a normal basis. There are just other considerations in the current climate that you should look at and determine whether or not you should provide an accommodation for an employee. What can I ask them? This is a question every employer is going to be facing. First, the employer may request information and medical documentation to determine if in fact someone has a disability under the ADA. This is whether or not an employee has a physical or mental impairment that substantially limits a major life activity. You can ask information and you can request medical documentation. Second, employers may request information from the employee to address fashioning whether or not a reasonable accommodation will address whatever accommodation is needed. The EEOC provides that sort of guidance to inquire as to how the disability creates that limitation, how the accommodation will effectively address the limitation, whether or not there's another form of accommodation that could effectively address this issue. These are all considerations. How long does the interactive process take? This is a good question. And it's going to be on a case-by-case determination, but temporary accommodations will be critical. You might need to temporarily grant the accommodation and engage in the interactive process and then modify whatever accommodation that you can provide to that employee. But, a temporary accommodation is a response that is been blessed by the EEOC. Extensions are also valid accommodation requests. So if someone's trying to request an extension to an accommodation, I would not downplay that. Just make sure that you take that request equally as you did the original request for time off or some sort of modification to the workplace. As always, an employer does not have to provide a particular reasonable accommodation if it would pose as an undue hardship, which means a significant difficulty or expense to the employer. Be careful here. And, these slides talk about what a significant difficulty is and what a significant expense is. And I can tell you that this is a pitfall most employers fall into, because just because an accommodation would cost the employer more money, or you can tie some monetary value to that, doesn't mean you can reject the accommodation. You really have to look at the factors and make a case-by-case analysis as to whether or not you can provide that and whether or not it would pose as an undue hardship. So questionnaires are good to use with your employees, and you can get ahead of a lot of these issues. What are some of the potential post-pandemic claims that we expect to see against employers? Pandemic-related harassment or discrimination claims. Okay, the claims may arise based upon natural origin, race, possibly other protected characteristics like age. Employers should take steps to address possible harassment and discrimination by preparing your managers, making sure that they have the information they know to make those sorts of decisions in real time. Consideration that the EEOC has pointed employers to is harassment of specifically Asian employees, which is a focus of workplace issues and potential claims in the future. Expense reimbursement claims. This is an issue in which if you have any employee working from home, you need to analyze, for internet costs, a portion of their cell phone, other reasonable expenses. These could fester claims, not now, but in the near future. And there's a lot of people on the plaintiff side of the bar which are starting to talk about what types of claims, class actions that they're going to bring after this pandemic is over. Best practice, make sure you seek employment counsel to put in a temporary telecommuting policy. This is where you set the expectations for all your employees. Properly calculating wages owed. I love this slide because this is very likely what's happening with some employees who are working from home. And how are they accounting for their breaks? When you're in the workplace, there's a lot of tracking mechanisms that employers can use. And when they're working from home, you need to be creative and agile. And, a proposed solution is the DOL has a, cell phone timekeeping system, which is free that you can utilize. So there's a lot of resources out there that these governmental agencies are providing. Off the clock claims. Again, when does an employee start and stop work when they're working at home? This is going to be an issue that all employers are going to have to think about for those that are working remotely. So you can have them sign and monitor and approve their own timesheets to make sure that they've accounted for all of their time. And the fact is they've taken all of their legally required breaks and make sure that they were timely, and that's something you're going to want to have them sign off on, especially when they're working from home. Disability leave claims, new leave laws mean new liabilities. So if you deny people's request for time off, you miscalculate their pay for the time that they're taking off because of the new leave laws. These are all pitfalls, and you might face a lawsuit in the future. How do you calculate a regular rate of pay for the new federal sick leave is an issue that you should talk about or think about, because it's different from just the regular rate of pay. Possible spin-off retaliation leave claims. So a denial of someone's leave could also have a spin-off retaliation case. Lastly, wrongful termination claims. There are a lot of practical considerations when considering a layoff or a furlough. Make sure that you're equally applying this and you're doing adverse impact analysis to make sure that there's no disparate treatment or impact on any specific type of protected class. There are federal and state WARN Act requirements depending upon how many people you are laying off. There are employment sick leave considerations, whether or not that this ties into the retaliation. Eligibility for SBA paycheck program protection program. If you're going to do a layoff, make sure that you've identified whether or not what effect it would have on the money that you receive from the SBA for any sort of repayment. Tax credits, that's an important issue to also know whether or not you'll still qualify if you either partially lay off people or completely shut down or turn it into a permanent layoff. Unemployment benefits, these are, there's been a change in the law and the amount of money employees are going to receive, so this is a consideration. And lastly, medical benefits. So whether or not an employee is entitled to certain benefits, post-termination, that's something you're going to want to consider, and these will all be basis for why employees during a economic downturn like this would be incentivized to bring a wrongful termination claim. So a few final thoughts. I know this is a lot to cram into 30 minutes, but remember, it's a big transition for all employees. Employee morale will be critical, and take time to mend. Train the management team to ensure the understanding of the new leave options, eligibility, and concerns. Communicate regularly with your employees, and also remind them of the benefits that are offered. These are all items that they've read about or saw in the news, and they would like to hear it from you. So I always think that's important. And request feedback, internalize it, and find a way to adapt and overcome every situation that we're dealing with. So I would just like to thank you and turn the slides over to Jill Grathwall, my partner from the San Diego office. Thank you.
Thank you, Chris. Thank you very much. That's a lot of great information there. Let's switch gears a little bit and talk a little bit about COVID-19 and the impact of workers' compensation. This would be an update from our April 15th webinar that is posted on our Wood, Gutmann, and Bogart COVID-19 resource page that you can refer to. We have Jill Grathwall, who's Defense Counsel for Workers' Compensation. She's going to provide us some updates and guidance. Jill, wow, I mean, when we say things are changing by the day, no joke, right? Governor Newsom just signed an executive order just yesterday. So let's begin there.
Yes, Tammy, it was a wonderful surprise yesterday afternoon. We knew it was coming down the pike because there has been legislation that had been previously proposed, but unfortunately this happened around noon yesterday where he gave his press conference, so we spent quite a few hours and a little bit of a late night preparing updated slides for you, all of you. So please, I'm sure there are going to be questions since it is brand new, but we can deal with those as Trey had advised. He'll take note of them and feel free to contact us with any questions that come up. So yesterday what happened was Governor Newsom identified the executive order that he issued, and this is now going to create a presumption that any employee who is not working from home is entitled to a presumption that if they have contracted coronavirus, that it is a compensable workers' compensation claim. This is a rebuttable presumption, and we'll talk about what that means in a little bit, but this is definitely far and away not what we anticipated he was going to identify as the executive order, but we'll discuss the merits of that and why he chose to do that. The presumption will apply retroactively to March 19th, which is when the stay-at-home order was first issued. So that's the importance of that date. Stay-at-home order issued March 19th, and it stays in effect for 60 days from May 6th, 2020. This is July 4th because we count actually 60 days. We don't just do 2 months. And then the order, what's also important for us to recognize is that it shortens the time employers have to accept claims. We have, prior to this executive order, you would have 90 days to investigate the claim and determine if it was compensable. Now it's reduced to 30 days. And again, this is only for COVID-19 claims. I've given you the link if you want to actually look at the order. Prior to the issuance of the order, there were 2 bills before the legislature. The legislature had been in recess since the stay-at-home order in mid-March and resumed May 4th before the legislature could make a determination as to whether or not they were going to pass either bill. Governor Newsom issued his executive order. So the question is, are these now moot? I don't necessarily believe the Assembly bill is moot, but the Senate bill is likely going to be moot at this point because the Senate bill was talking about creating a rebuttable presumption. The Senate bill was only going to provide that rebuttable presumption for essential workers or critical workers as they identified it. And it was a work in progress because they hadn't put in what we call a sunsetting clause as to when the statute would expire. Well, Governor Newsom kind of took that out of their hands and put in this executive order that said any employee who is not working from home or who is at the employer's place of business is entitled to the rebuttable presumption. And he also put in a sunsetting clause identifying when it would terminate. He also has put in several other provisions to the executive order that we will discuss regarding TTD and the investigation and all of those issues. But so I believe the Senate bill is now moot, but the Assembly bill was going to create a conclusive presumption that COVID-19 and other infectious diseases arising out of employment for police, firefighters, and healthcare workers is presumed compensable. Conclusive presumption means that we can't rebut it. It doesn't matter if they may have gotten it at home. This is going to be if they were a firefighter or a healthcare worker or a policeman or woman, they were entitled to a conclusive presumption. If they were diagnosed with COVID-19, it was going to be compensable. There was no way to rebut that. In our favor, for the employers and everyone on the line, the beauty that we have a rebuttable presumption, which means what do we do with that information? And we will look into that and discuss what you can do in terms of investigation to rebut this presumption. Prior to the enactment of the executive order, State Compensation Insurance Fund had already put in place that in any employer that employs essential workers under the under SCIF will have a presumed compensable claim. And that was it was a conclusively presentable claim for SCIF essential workers. Well, Governor Newsom has now added that for non-essential workers, they have a presumed compensable claim. So there will be a delineation for any claims with State Compensation Insurance Fund, which currently has 11% of the insurance carrier work for workers' compensation in the state of California. So that's important to recognize. State Compensation Fund was way in front of this, and then Governor Newsom expanded on that. But under the SCIF structure, any essential employee would still have a conclusive presumption. It would be the non-essential employees who were working outside the home that will be entitled to the rebuttable presumption. What becomes important for you as employers out there is when should you be providing a claim form? First and foremost, you have to recognize that when you provide a claim form, this is not an admission of liability. It's a statutory right that must be provided to the applicant, but it is not an admission for liability of your part. It just starts some certain statutory things in effect that you now have to do as an employer and what your insurance carrier has to do. First and foremost, a claim form, which is also called a DWC-1, and everybody calls them something different, must be provided to an employee if they ask for it. This is not a time for you to say to your employee, oh, I don't think you really have the injury and it's related to work. That has nothing to do with it. If they ask you for a claim form, you must provide the claim form. And that comes under Labor Code Section 5401. And what that's talking about is that if you have, as an employer, knowledge that an injured worker has an injury that may be workers' compensation compensable, you must provide a claim form. So Labor Code 5401 is identified. I've given you the examples here. And the forms of knowledge can be different. It could be they've requested the claim form, they've provided written notice to you, they've sent an email, they've made a phone call, any type of knowledge such as that they may have a workers' compensation injury, you should be providing a claim form. So this knowledge can come from a coworker, the disability slip they've provided, a supervisor, any form such as that. Just knowing that the injured worker has COVID-19 does not require you to provide the claim form. That's something you have to recognize. It has to be the employee is making the claim that their COVID-19 is industrial. So that is going to be a question we are going to see consistently happening with in your workforce. So what do we do in those situations? Tammy, I think the question we were facing was whether or not if it's just a request that the employer has now called in and said, you know what, I can't come into work today. I've been diagnosed with COVID-19. Does that mean we have to provide the claim form?
Right.
And
we have that question frequently. Like what? Yeah. Go ahead.
Right. I've got that question this morning. You know, we get it all the time is what do we do in those situations? And Tammy gets it because Tammy's on the front line because her employers are calling her saying, what do I do? So then typically she'll ask us that question or she'll ask the carrier that question, what they want us to do. And this is what, if they're not calling you asking for a claim form, you don't necessarily have to provide the claim form. But it is triggering an investigation for you because you can anticipate, especially as, this executive order issued via press conference yesterday. I couldn't even find it online until 2 hours after the press conference. So all of those people sitting at home or all those people at work or watching the news said, oh, wait a minute. I have COVID-19. Can I now file a claim? So I would anticipate there is going to be a flood of claims being made, whether legitimate or not, as to whether or not their COVID-19 claim is compensable. So if someone calls you and says, you know what, I've been diagnosed and I can't come to work, or I won't be working the next few days, whatever it is, start that investigation period because you can anticipate that a claim is going to be filed in California now because of this new executive order. But these are other instances of what to do. And this is the investigation. This is the beginning of the investigation. Take a look at some of these questions I've identified. If you have a direct request, yes, you provide a claim form. If you are an employer of essential workers, such as first responders, healthcare workers, food service or grocery store employees, is there a likelihood that they were exposed? Could they have been part of what we call the supply chain? And already there was statutory framework out there that essential workers were going to have a presumption. Now we can assume, now with the executive order, that these workers are going to file claims if they've been diagnosed. The very basic question under the executive order is, did your employee work at home or did they work in your office or in your store? Well, if they work at home, you still have to provide the claim form if they ask for it, but that's the beginning of the investigation as to whether or not it's a presumed compensable claim. So those are questions you have to start asking and keep track because I didn't give out all of the definitions outlined in the executive order, but one of them has to be that they must have been at work or outside of the home 14 days, at least 14 days prior to the notice. Well, for those claims that, if you sent your workers home back in March and they're making a current claim for COVID-19 or diagnosed in the last week or two, that's not necessarily a presumed compensable claim. So this is what you have to start keeping in mind as these are reported to you and start taking notes when you have people reporting a claim, contacting you about their diagnosis. Every employer is going to have to look at the totality of circumstances when assessing whether a claim form should be provided. Examples are above on that slide there. The reason we want to provide a claim form is it's a protective measure. And first of all, from our perspective as your defense counsel is it starts the statute of limitations, because in order for a claim to be considered compensable, it has to, number one, first be filed. We have to be aware about it. But injured workers typically have 1 year from the date of injury to file the claim. So if they're diagnosed on April 1st and they fail to report the claim to you, then with the executive order now being in place and well known, now the question is going to be, well, now they know they have a right to file that claim and that they should be reporting the claim. If you think this is an appropriate instance where you should issue a claim form, you should do so. Because if they don't complete the claim form, then you have a basis to deny it for lack of proper timely reporting. There's also a way to consider a claim form as a protection. You don't want to create a culture where your workers are afraid to report injury. Because if you create that culture, then when there's an appropriate injury and you can take care of it, they're not reporting it. So for instance, in the COVID-19 realm, if you have workers who you know do not have the ability to, number one, provide proper health care for themselves, reporting the claim to you is a way for them to get medical treatment. Now, I'm not saying you should accept the claim for that reason or that you should deny the claim because you don't want to provide those. It's just a protection for you and your company. Now you've been made aware that, hey, I have a worker that has been diagnosed with COVID-19. What do I have to do to protect the coworkers, my vendors, my outside people that person has come into contact with that you may need to protect? If you have, for instance, vendors who come into your place of business, these are the things that are required. We need to know and we need to evaluate in terms of protecting ourselves, protecting our workers, protecting coworkers, and protecting your company. And if the claim is reported to you, there are other ways we can look at what that protection is. And that's why we want to take a look at these situations on a case-by-case basis as to what it means when a claim is reported to you.
That's really good, Jill. I'm glad to hear that there's protections when our clients provide the claim forms in DWC to their employees. Thank you.
Right. I mean, there's a protection on a lot of realms. I mean, because part of the protection also for you as a employer is that you now have the resources of the insurance company or your TPA, who are maybe better equipped to perform an investigation, to ask the appropriate questions, to provide the medical outlet, to identify for you what testing needs to be done, what you are statutorily required to do. So that's why it is important that, we shouldn't be in a culture of we don't want injuries reported, because reporting injuries is how you figure out what to do best in your company, whether it be a COVID-19 claim or a non-COVID-19 claim. It's how you can assess best practices going forward and prevent additional injuries or additional COVID-19 claims from happening. So after the claim form has been provided, what does this mean? This means that you as an employer and or your carrier have to duty to investigate that claim. Again, the provision of the claim form is not an admission of liability, but it triggers certain statutory periods. If it's a non-COVID-19 claim, there's a 30-day investigation period. That's standard. For COVID-19 claim, there's now a 30-day investigation period from when that claim is reported to you. And that, again, think about it, did the individual work from home or did they not? The executive order is very clear. This applies to employees who work from home. Now, you may have a hybrid employee, and then it would be, again, it's a case-by-case basis. But evaluate whether this person worked from home, and if they did not, then you have a 30-day investigation period. But if they're working from home and have been working from home since the stay-at-home order is in place, they do not get that 30-day investigation period. So it's very important to keep track of those situations. The reason this is also important, this investigation period, is during this investigation period, up to $10,000 in medical treatment is to be provided until the claim is either accepted or denied. So in that 30-day period, there's up to and that hasn't changed due to the shortening of the investigation period. During that 30-day investigation period, up to $10,000 of treatment can be sought by the injured worker until the claim is either accepted or denied. And again, in situations where the injured worker has no access to health care, is perhaps the workers' compensation healthcare system the only available remedy for that employee? And if they're a valuable employee to you, this is a consideration to be made while you're investigating the claim.
And also to add to that, if there is a COVID-related diagnosed claim, the WCIRB, you know, we all know that anytime that there's a payout of medical or payout of indemnity, that it's going to impact an employer's experience modification rate. Well, the WCIRB has issued an order that they will be redacting all COVID-related claims out of your experience modification rate. So if you did have something like that, then at least it won't affect your XMOD. So that's good that's a win for employers.
Right. And that was a protection put in place specifically because they didn't want this blanket, everyone denying COVID-19 claims as compensable, to avoid the provision of treatment, to deny them from day one. Now with the executive order in place, we have some preventions there, but that was one of the reasons they did that, to provide workers an ability to get the medical treatment they may need to recover from COVID-19. Once a claim form is provided, or even that you have knowledge, the injured worker hasn't asked for a claim form, but you have knowledge, start doing the investigation. The investigation can take the place of I've given some factors here. Inquire, and you can do that. If the injured worker is not represented by counsel, you have the ability to ask questions. And they have now put out there now it's a HIPAA issue. The HIPAA is almost out the window in terms of investigating this specific injured worker's claims. First of all, when claim form is provided to you by the injured worker, of course, tender it to your insurance carrier and work with them as much as possible to investigate this claim. Most insurance carriers, the adjuster has a list of questions they automatically ask. I fully anticipate that all of the adjusters now, if a COVID-19 claim has been made to them, they have a separate list of questions that are very specific to COVID-19. And some of these questions are what I've identified here. Inquiries about the employee's onset of symptoms. Did they actually get a diagnostic test, or are they just symptomatic and they believe they have it? Well, there's a difference. It has to be under the executive order for it to be a compensable claim. They have to have an actual diagnosis by a qualified medical provider. It can't be, they think they have the symptoms and, I have a temperature. They have all of the symptoms, but they have not yet been tested and been diagnosed. That is not sufficient. If they have been diagnosed, the CDC is having them complete tracing paperwork, and they will be provided a copy of that tracing paperwork. If they have a copy of it, you could ask for it. Your carrier can ask for it to find out when they were diagnosed and what did they report as their potential contact when they were diagnosed and reported it to the CDC. You want to look into potential bases for exposure. What are their family members doing? Their family members, have they been exposed? In those type of situations, these are questions that can all be asked. Do they have specific pre-existing conditions or comorbidities that may have made them at a higher risk or more likely to be, number one, exposed, and number two, to have a resulting diagnosis? What are their contacts with others inside and outside of work? Do they have children in the home? Do they have other people who are working outside the home on a daily basis? Those are the questions that can be asked. What is their general risk for exposure to the virus? Again, that would go to what type of job do you have? Is it a retail store, or is it primarily office work, where chances are they didn't have outside exposures coming in? So these are all questions we want to look at. And then another important question that I didn't include here is, when did they last actually physically work at your location? Because again, that is important in terms of when they were required to report the claim and when the diagnosis came into play. If your operation shut down on March 19th due to the stay-at-home order, they will not have a presumed compensable claim because they were not working outside of the home. So just because they may still believe, I contracted it 6 weeks ago when I was at work, but that's not going to give them a presumed compensable claim. So that's why we have to take a look at the timelines and if they're coming and going from your office, hopefully you're keeping careful track of who's coming into your office and when. COVID-19.
So I think this is a great screen.
Right.
We will speed it up. I did just look at the time. It is 12 o'clock, which is the time we were supposed to end. So
Right.
I think we'll speed it up here, but I think we'll probably, for all of our participants, we will conclude here in the next 5 to 7 minutes. Do you think, Jill? But I think
Yes,
that
that's
last
fine.
screen was really good. So
Yes, that checklist I think is very helpful, and keep certain specific track of that one, because that's going to be most important as we investigate these claims. An important change with the executive order is now if the injured worker has a COVID-19 claim and is reported to you and it is compensable, even during this investigation period, all sick leave must be exhausted before TTD is owed. So that's something to keep in mind as claims for TTD are being made. And the certification for continued TTD, instead of it being every 30 to 45 days, it is now every 15 days for compensable COVID-19 claims. So that's a shortened time period for reporting. And then we look at other issues of, in terms of TTD, whether they're entitled, if they're out of work for other injury, an orthopedic injury, and now they have a compensable, if they're out of work for a compensable orthopedic injury, and now they're been diagnosed with COVID-19 and are TTD because of the COVID-19, that is not paid on your dime, because that is not part of the workers' compensation injury for which you're paying benefits. So and it would be a question, we'll look at each individual case. And then in terms of whether or not, if they're working modified duty, and there's a lot of differences of opinion about this, but if you have them working modified duty and now the stay-at-home order has meant you have had to close down operations, are they entitled to TTD? My position and the position of many of my colleagues is no. Then they're getting the state the state benefit through EDD. And I would talk to, if you employers have any questions, or your carrier has any questions, we're open to discussing it. But that's been the standard position we are taking in these situations. Workers' compensation proceedings are going forward. The most important one for us is depositions. We are still proceeding with depositions because they're a necessary part of the investigation process. So obviously all parties have to agree to appear by video, whether it be by Zoom or WebEx. And we are finding that 90% of our opposing counsel are in agreement to that, because in all honesty, that's how they get their fees. So employers are also entitled to participate in these depositions. And, we've had that happen in several instances. One of the big issues that's causing delays, and Tammy was going to bring up some questions about this, but we are short on time, is medical legal evaluations have been causing the delays in resolution of your claims. And that's because doctors also are somewhat reluctant to have patients in their office unless it's necessary or COVID-19 related. So the state is promoting some emergency regulations to address these concerns, and is giving the QMEs and the parties, or the AMEs, and these are the medical legal evaluators who provide final opinions on workers' compensation claims. They're giving them different options on how to proceed. And there are 3 different options. Each of them have their own inherent problems, and I've identified the problems in these slides. But if we want to move these cases towards towards resolution, then we certainly want to make sure that we can have the evaluations take place in whatever means necessary. And we would have to assess that on each case and what would be the best way to proceed. The last couple slides I've provided regarding COVID-19 and OSHA. And generally, California is following the federal OSHA guidelines as it relates to COVID-19. And they're following it. If it's reportable under federal guidelines, it's going to be reportable under the California guidelines. So that's slides 53 and 54. So again, take a look at those slides, and feel free to either contact us or contact your other employment counsel with any questions you have regarding the Cal OSHA regulations. But the Cal OSHA has best practices both in terms of return to work when you're open at work, and also what's reportable under Cal OSHA. And I've provided the links to those sites on our last slide here.
yeah, thank you, Jill, for being such a reliable resource for our clients and providing them the up-to-date information hot off the presses from last night related to workers' comp. So we'll go ahead and turn it over to Trey.
Yeah, just wanted to thank everyone on behalf of Gutmann and Bogart, our clients, and other members that have joined this webinar today. And a big thanks to our guest speakers today, Chris Harmon and Joe Grathwall, Lewis Brisbois. Again, if you have any questions, feel free to reach out to your broker, your employment counsel. We're here to help you. And as we continue to navigate these uncharted waters, be safe and be well. And thanks again.
Hey, Trey, one quick point.